Picture this. A client walks into your office. They have a problem, and they're looking to you for the solution. But here's the thing. Before you can even think about what to do, you have to know where to go. Picking the right court is honestly the first, and maybe the most critical decision you'll make. So let's get our bearings and map this thing out together.
This video was created with AI to support SQE1 study. We are independent and have no affiliation with the SRA, Kaplan, or the SQE. We do not share exam content, and our videos are for informational purposes only and should not be used as legal advice. Please check and refer to primary legal sources and recommended prep guides as you study.
Welcome to New to Law. This is our self-study series designed to get you totally prepped and exam ready for the SQE. Now, if you've ever looked at the court system in England and Wales and just felt completely lost in a maze, well, you are in the right place. Today, we're going to give you a clear, simple map of the whole system so you know exactly where you're going every single time. The key that unlocks this whole system, it's one word: jurisdiction. Think of it like this. You wouldn't take a broken watch to a baker, would you? It's the same idea. Every court has its own specialty, its own specific power to deal with certain types of problems. So jurisdiction is just that, the official power of a court to hear a case. Get this right, and you're on your way. Okay, so where does this whole legal journey begin? Well, for pretty much every single case, it starts in what we call the courts of first instance. You can think of these as the main entrances to the justice system. It's where the story of a case is told for the very first time, and where those initial crucial decisions are made. The second you step inside, you're going to see two main doors. Over on the left, you've got the county court. This is where civil law happens. So that's disputes between people or businesses. Think broken contracts, personal injury claims, that sort of thing. The goal here is to find a remedy, usually some kind of financial compensation. Then on your right, you have the magistrate's court. That's for criminal law, where it's the state versus an individual. Here, it's all about determining guilt or innocence, and then, if needed, handing down a sentence. Right, now here is a huge fact for your exams, so listen up. The magistrate's court is the starting point for every single criminal case. Everyone. It handles all the less serious crimes, what we call summary offences, from start to finish. For those middle-of-the-road cases, the triable either-way offences, it'll decide whether it has the power to hear the case itself or if it needs to be sent up to the Crown Court. And for the most serious crimes, it just deals with the very first hearing before passing it on. So what about the Crown Court? Well, this is where the really serious criminal trials happen, what we call indictable offences. Think of the big courtroom dramas you see on TV, with the judge in full robes and a jury of 12 people deciding the verdict. The Crown Court also handles those more serious triable either-way cases that get sent up from the Magistrates' Court, and it's also where you'd go to appeal a decision from the mags. Okay, let's hop back over to the civil side of things. So you've got a civil claim. How do you know whether to go to the county court or the high court? Well, in most cases, it really just comes down to the money. The general rule of thumb is this: if your claim is for $100,000 or less, you start in the county court. Simple as that. There is a little exception for personal injury cases. That limit is $50,000. Think of it as a financial sorting hat for civil claims. Now, for the really high-value cases, or the ones that are legally super complicated, you're going to end up in the high court, and it's split into three specialist divisions. First, you've got the King's Bench, which handles major contract disputes and torts, which is just a fancy legal term for a civil wrong, like negligence. Then there's the Chancery Division. That's all about business, property, and trusts. And finally, the Family Division, which, as you can guess, deals with the most complex and sensitive family law cases out there. But what if you lose? What if you totally disagree with the decision that was made in one of these courts of first instance? Well, that's where the next level of the system comes in. So let's climb the ladder and take a look at the path of appeal. The next step up is the Court of Appeal. And here is the absolute crucial thing you have to remember. The Court of Appeal does not do retrials. They don't hear from witnesses again. They don't look at new evidence. Their one and only job is to look at what happened in the court below and decide, did the judge make a mistake in applying the law? It's all about the law, not about rehearing the facts. And then, right at the very, very top of the entire system, we have the Supreme Court. This is the final court of appeal in the UK for both civil and criminal cases. But getting your case heard here is incredibly rare because its job is very, very specific. And honestly, this quote from Lord Bangham just nails it. The Supreme Court isn't there to fix every single mistake that might have happened in the lower courts. Its real purpose is to make decisions on points of law that are of genuine public importance. So even if an error was made, the Supreme Court will only step in if the legal question itself affects pretty much everyone in the country. So the normal route is High Court, then Court of Appeal, and then, maybe, if you're lucky, the Supreme Court. But in very rare and exceptional situations, there's a kind of shortcut. It's called the leapfrog appeal. This lets a case jump straight from the High Court to the Supreme Court, completely bypassing the Court of Appeal. But this only happens when a case is so urgent and so nationally important that it needs a final answer from the highest court in the land, like right now. A perfect example of this is the famous Miller case. This was all about whether the Prime Minister could legally advise the Queen to suspend Parliament. I mean, this was a massive constitutional issue that needed a final answer, and it needed it fast. The case was of such exceptional public importance that it leapfrogged straight to the Supreme Court so they could make a definitive ruling. All right, we have covered the entire court hierarchy from the ground floor right up to the very top. So, to make sure all of this is really cemented in your brain for the SQE exam, let's test that new knowledge with a couple of practice questions. Okay, let's put it to the test. Question 1. Your client has a property dispute and it's worth exactly $100,000. Which courts have the power, the jurisdiction, to hear this case? Have a quick think, pause if you need to, and we'll walk through the answer in just a second. And the correct answer is they can start their case in the county court, or they can choose to go straight to the High Court. So why is that? Okay, 2 steps. First, we know that property disputes are the specialism of the Chancery Division of the High Court. And second, because the claim is for exactly £100,000, the claimant gets a choice. They can start their case in the county court, or they can choose to go straight to the High Court. So both courts have jurisdiction. All right, on to question 2. And a simple contract dispute is heard by a district judge in the county court. You lose. Now you want to appeal that decision. Where is your appeal most likely to go? This is a bit of a tricky one, so really think it through. The answer is a circuit judge in the county court. Now, this is a classic trap, so pay attention. In the civil courts, an appeal usually goes to the next level of judge up, not necessarily the next court up. A district judge is the most junior judge in the county court. The next judge up in the pecking order is a circuit judge, who also sits in the county court. So your appeal is actually heard in the very same court, just by a more senior judge. That is a crucial difference to remember. So let's wrap it all up with a final checklist for your exam prep. 3 key rules to drill into your head. 1. Every single criminal case starts in the magistrate's court. No exceptions. 2. For civil claims, that $100,000 figure is your magic number. Generally, anything under that starts in the county court. And 3. The Supreme Court is reserved for the big, nationwide legal questions. And please, please, please do not forget that common pitfall we just talked about with civil appeals. It's about the next judge up, not the next court up. Nail that down and you'll be in great shape. Thank you for joining us for another new law breakdown. See you next time.